Welcome, listeners. This is Sanjog Aul, your host, and the topic for today's conversation is complex case law eDiscovery. Is predictive coding a panacea? And I have with me Shannon Capone Kirk. She is the eDiscovery Counsel at Ropes and Gray. Hello, Shannon. How are you?
Hello. I'm great. And you?
Very good. Fabulous. Thank you for joining us. So, just wanted to, in this particular context, get your wisdom and insight when it comes to predictive coding. What we have learned all along is that reviewing huge volumes of electronic documents is anyway a painstaking process. And predictive coding has been provided as a solution, it's been offered as a solution. How well does this actually work?
Well, it can work well, but it depends on a few things. It depends on the volume of material that you have, the volume of data. It depends on the tool that you're using, and it depends on what your goal is. So let me break that down a little bit. When I talk about volume, I mean, of course, the amount of data that you have to review. So predictive coding is, I have found at least, more effective, more cost-cutting, and useful if you have a large amount of data, right? The tool, of course, is going to also seriously impact how well it actually works. And keep in mind that predictive coding is actually just a very broad term that covers a number of different products. And actually, technically, predictive coding is really applied to only one tool out there. And I believe that they either tried to or have a trademark on that phrase. However, we all use it to refer to what's also known as, more generally, technology-assisted review. Right. And so what we're really talking about here is where a review platform will learn from attorneys who teach it what it's looking for, what the attorneys are looking for, and the computer assists them in bringing back and calling back like documents, so to speak. So that's a very simple way to look at it. So whether or not predictive coding is a useful solution is, of course, going to depend on the tool, and all of the tools are different. They all operate very differently. So it's not like a Coke, Pepsi kind of comparison. They all do functionally very different things. And then finally, what is your goal, right? So I have found that predictive coding is best when you're dealing with a larger population of documents and you really just want to use the tool for a binary decision, and that being responsive or not responsive. So far in my experience, a particular quote unquote predictive coding tool was very useful in cutting costs when we were able to just schlep off, a large amount of non-responsive documents, and we were really truly making a binary responsive, not responsive call. I have not had good experience in using the tool for more nuanced issues or complicated issue finding. I have found that it has not been effective in at least the cases I've used it for that. Of course, I'm not speaking beyond what I've actually done, and there could be other attorneys out there who have been able to use a different tool in a different way.
So, while predicting coding is supposed to identify relevant documents, but you still know that the final set which is produced has to be agreed upon by human beings who are representing both parties. When it comes to that, do you think you can say that predictive coding can only go so far? And then if this is the case in any ways, how do organizations justify investing in it and actually using the software?
So let's back up a little bit, because you said something in there that I feel we need to clarify, because there is this, and I'll call it a misunderstanding that the final set of documents when using predictive coding has to be agreed upon by both parties. That's not the case in my opinion. The producing party has a duty, no doubt, to conduct a reasonable search of relevant or potentially relevant documents and conduct a search of those documents and review them and produce them, right? Now, there could be this misunderstanding about predictive coding because there's been two cases in the last year, the De Silva case coming out of the Southern District of New York, and I believe it's called Global Aerospace which is a Virginia state court case in which both of the parties in both of those cases agreed to a predictive coding review methodology in which they would share the seed sets of the documents and the iterations of those documents, and also is sharing with opposing party, the producing party, sharing with the opposing party, documents that were coded not responsive. And the reason for that was the producing party agreed to allow the receiving party to sort of cross-check their work. In other words, as you're saying, agree upon essentially the methodology and ultimately the final set. Now, not everybody agrees that that is the correct approach. And in fact, in the Clean Products case in the Northern District of Illinois before Judge Nan Nolan, the plaintiffs in a large antitrust matter tried to compel the defendants to use predictive coding, or something similar to predictive coding that they called something else. I can't think of it right now. In any event, that process that they proposed, the plaintiff proposed, would have required that sharing of the seed sets and sort of that, involvement of both parties in the review process. Ultimately, through a series of hearings, the judge determined that no, it is actually up to the producing party how best to evaluate their review methodology. And she cited Sedona Principle 6. Now, Sedona Principle 6 comes out of the Sedona Conference, which is a group of lawyers, industry professionals, and judges who have devoted their time to creating principles for eDiscovery and other issues as well, and they're highly regarded and cited in numerous cases. And Sedona Principle 6 states that, quote, the responding parties are best situated to evaluate the procedures, methodologies, and technologies appropriate for preserving and producing their own electronically stored information. So you see, that gets us away from this notion that in all cases, this final set or the methodology to get to the final set must be agreed upon. Now, of course, if the receiving party does not think that the producing party produced everything or did a reasonable search, they can make that argument. And I think I interrupted you.
No, actually, it is good that you finished on this note. And what basically we are trying to explore here is this predictive coding technology actually can make the costs go lower, basically for cost reduction, can it be used, and it can actually make the process more efficient and better. Is this primarily used by general counsels and attorneys, and you actually advocate it?
So I think you said in there primarily. No, not yet. It is not primarily advocated by general counsel or attorneys yet. However, it is certainly a topic of serious consideration, and it is something that I always evaluate in every case now, whether it would be appropriate in that particular case. Will it save money? As I mentioned, if used correctly on the right case with the right tool, yes. And for example, I had a case where we estimated that the review, if we had done it in the traditional method, would have taken 12 weeks and cost a certain amount of money. We used predictive coding, however, to cut that review down to 3 weeks, and thereby cutting the cost of attorney time by more than $300,000. And so in that case, you can see that there are serious cost savings to be had, which is why people are paying attention to this.
And in terms of the intelligence of this technology that has been shared with the rest of the world, is that truly that Star Trek version of a self-learning type of technology that the more you use it, the better it gets in trying to help find relevant documents?
It's not Star Trek, and I wish that there was such a thing that I could just plug in and tell it what I was looking for, and the magical Siri would come back with all of my responsive documents. But you know what? We're just not there yet. However, it does seem that the better the human teachers are to the tool, and the more time and iterations that those attorneys spend with the tool, the better the tool is, and the better your results will be. Now, keep in mind, though, that predictive coding is just one tool. It is one tool in the whole arsenal of what lawyers have before them nowadays to conduct efficient and cost-effective document review. So it should not be the only tool to be used. There are other technologies out there that live in tandem with predictive coding. You still have traditional search terms, and I'm not convinced that those must die a quick death. There is still use to some degree of some level of search terms. There's also, as I mentioned, the technological tools. There are conversational patterns that the tool will provide to users, visual depictions, so to speak, of who's talking to who and when, which helps you to identify relevant conversation threads, relevant folks who perhaps you haven't thought as, time frames and spikes in conversations that are helpful to zero in on quickly, i.e. cutting down review time. There's also more advanced deduplication tools out there, which allows you to apply coding from to one document to a number of documents, whether they reside as attachments to an email or within users' file repository. I was just going to add that there's issue categorization, there's also automatic timelines. So all of these things all together should live with predictive coding to make for smarter reviews.
Let's take a quick break. When we are back, we will look at the aspects of eDiscovery that you feel may not be best suited, no matter how sophisticated this technology becomes. It is not as suitable for the overall eDiscovery process. But we'll explore that more when we come back. Please stay tuned.
Take control of eDiscovery with flexible integrated solutions designed for early data assessment, processing, document review, and litigation presentation. LexisNexis offers comprehensive solutions that work together as well as with other industry-leading tools to help you maintain a seamless chain of custody throughout discovery. Most of these solutions can be offered in a hosted environment with access to fully customizable support resources dedicated to your success.
You are listening to CIO Talk Radio Viewpoint.
Welcome back. So, Shannon, to what degree do you think seasoned attorney like you and others that you know can actually rely on this predictive coding technology? In your experience, what aspects of eDiscovery cannot be programmed into such software? And also, are there any possibilities of missing documents that could pose risk? And also, could it be possible that it could introduce false positives?
Sure. So I'll tackle the first part of your question. To what degree can attorneys rely on the predictive coding? Well, seasoned attorneys should rely on predictive coding only to the extent that the folks that they have assigned to teach the tool are actually teaching the tool in the manner in which is appropriate and reasonable and will result in the best use of the tool. So part of it is definitely dependent on human input. So it is certainly not the case that we can just simply rely on the tool. A large part of it is who is doing the teaching of the seed sets. And the seed sets, of course, are a statistical sample of the entire corpus of documents that you code as a human reviewer. And then that is what is teaching the whole system. So part of this, as a seasoned attorney, to understand is that it is certainly something that relies on human input, and therefore whatever degree those folks are knowledgeable is the degree to which you could rely on the tool. Also, the tool itself, it depends, and all of these tools are different. Seasoned attorneys should do their own homework and testing on the reliability of these tools. And to my knowledge, no specific tool has actually been tested in terms of technology by a court and found to be not adequate or adequate. What the courts have said so far is, yes, what I have heard so far from you, party, plaintiff or defendant, is that this is a reliable tool, and I have no reason to disagree with that. And certain studies show that technology-assisted review may be more effective than human review. So I will allow it, right? The next part of your question is what cannot be relied upon within these tools. I have found so far that predictive coding or technology-assisted review is not very effective or precise when trying to find or ferret out work product or attorney-client communications. To a large degree, that is still very human dependent on finding those, and I've not found a tool yet that is very good at being accurate with respect respect to those very important calls, by the way. And that, is primarily why we do a large part of document review, is to make sure that we are not producing privileged communications or work product. Lastly, the last part of your question had to do with risks. What are the risks of missing documents with technology-assisted review, and what are the risks of finding false positives? So, of course, the risks of not finding otherwise responsive documents are that you, as counsel, will not be compliant with the rules and the requirements of your professional responsibility rules and with the federal rules of civil procedure that you conduct a reasonable search. What it will all come down to is an evaluation of the process that you put in place. What was the procedure? What was your QC? Who did the review? And truly, how well did you run and supervise that review? It will come down to the process, right? So your risk, of course, is that your process was not good, and therefore you will be found to have not complied with your duties as counsel to conduct a reasonable search. The risk, of course, is that could lead to sanctions. The risk of finding false positives is that, that again speaks to not having a good process, right? If you're finding and continuing to find too many false positives, it should be telling you one of two things. Either A, your tool is not good, or B, your process is not good. And of course, the risk of having too many false positives is that you have now run up your review costs and you're not really saving the client any money.
Finally, what do you really want from predictive coding, and how is that any different from what the corporate general counsels expect from it?
Of course, what I want, which I think is 100% aligned with what corporate general counsel want, I think, is that I want to save time and I want to save money. And I want to save time because I want to meet my deadline. And I also want to save time because it reduces the amount of attorney hours having to do review, which therefore saves the client money. But at the same time, I also want a tool that is accurate, because I have as a duty, as an attorney, I have a duty, and my client has a duty to be compliant with the federal rules of civil procedure or the state court rules, whatever court I'm in, to conduct a reasonable search and to produce documents that are responsive or will lead to relevant information, admissible information. And so I think that those goals of what I want out of predictive coding or technology-assisted review should be consistent with what corporate general counsel would want as well.
Once again, thank you, Shannon, so much for sharing your thoughts and insights about complex case law, eDiscovery, and how predictive coding can and or cannot add value.
Thank you for having me today.
Thank you again. And listeners, I invite you to find more conversations about eDiscovery on our website at www.ciotalkradio.com/eDiscovery.